She heads the Bangalore branch of Ultrasit Global and has over 10 years of experience as an attorney and IP consultant. Her expertise has involved working with corporations. She specializes in prosecution of intellectual property both in India and internationally, managing IP portfolios, advice, and consultancy in respect of intellectual property protection and IP litigation. She is credited with publication in a national journal. She holds a degree in Bachelor of Law Honors from Tamil Nadu, Dr. Ambedkar Law University, Chennai. Once again, we welcome you both, ma'am, and over to you for the session.
Thank you for the introduction, ma'am. So before I start the presentation, I just want to confirm if you can see my screen. My presentation viewable, ma'am?
Yes.
Okay, thank you. So good morning, everybody. I'm Fulma, heading the Trademark and Copyright Department in Ultrasit Global. So throughout the series of various lectures, I hope that you all would have got an insight about what is intellectual property, its types, etc. and etc. So today I'm here to discuss a type of IP, that is copyright. So I'll be discussing what is copyright, types of copyright, who own the copyright to a work, rights and copyright, the duration of copyright protection, and my colleague, Ms. Shelley, will be speaking about infringement of copyright, the registration process in India and internationally. So what is intellectual property? So intellectual property enables individuals to own what they have created and invented in the same manner in which physical property is owned. So in simple terms, IP is a creation that is a result of human intellect. So traditionally, intellectual property is divided into two categories. So one is industrial property, which covers patents, trademark, industrial designs, and geographical indication, and copyright, which covers literary and artistic works. So what is protected in copyright? So as simply speaking, copyright is a property right. So a person owns a copyright as much as he owns a car. So like you cannot use someone else's car without the owner's permission. You generally cannot use someone else's copyright without obtaining their consent. So copyright laws in India. So copyright laws in India is governed by Copyright Act 1957, which has been amended 6 times with the last amendment in 2013. And the Copyright Rules 2013 came into force from 14 March 2000, which we follow now. And this act extends to the whole of India. So what is the purpose? So what is the point of copyrighting your work? So the main object of copyright is to encourage authors, composers, artists, and designers to create original works by rewarding them with the exclusive right for a limited period to exploit the work for monetary gain. So it is generally to encourage authors, composers, artists. So the second objective of copyright law is also to protect the author or the creator of the original work from the unauthorized reproduction or exploitation of his or her materials. So I'll just summarize what is copyright. So it is, as I mentioned earlier, copyright is an exclusive legal right to the original creator of the work, and the creation should be original. So there is no copyright in ideas. So the third point I have given, that these ideas are not copyrightable. So which means that in the copyright subsists only in the tangible form in which ideas are expressed. So ideas are not copyrightable unless developed sufficiently. So it is the expression of the copyright which is protectable as copyright. So see, I'll just give an example. I have an idea to produce a play about the Indo-Pakistan war. I cannot prevent others from producing plays about the same subject. So protection is given only to the expression of the idea and not the idea itself. So unlike a patent, a copyright gives no exclusive right to the art disclosed. protection is given only to the expression of the idea and not the idea itself. So then copyright is a negative right. So what is negative right? Copyright is negative right since it is not the exclusive right to do something, but it effectively stops others from doing a series of acts. So there is no registration formalities required. So it protects the work as soon as it is created and no registration formalities are. However, it is always advisable to obtain a registration for better protection. So a copyright can be defined as a form of intellectual property protection granted to the creators of original works of authorship. So to obtain copyright, there is no requirement that the literary and artistic work should be good or have artistic merit, like unlike industrial applicability. Because for patent, you should have that some industrial applicability. But here, copyright, you do not have such requirement. The condition for copyright protection is originality and fixation of work in a tangible medium. Generally, copyright may be literally regarded as the right to copy of an original creation. So what does copyright protect? So the Copyright Act 1957 gives two types of copyright. So one is which we call as original works, that is literary, artistic, dramatic, and musical work, all of which are the product of the brain and imagination of the author. And other part deals with the sound recording, cinematograph, films. All of them are works based upon something which has been produced by some author, but the work which is copyright is the product of the applications of some special medium. So you need some special technique or medium to incorporate these works. So the cinematograph, film, and sound recording, you need some special technique, skill, and the like, and the recorded in the form of edition of some work for the benefit of the public. So what are literary works? So a work may be considered as literary if it is expressed in printing or writing or in some form of notations or symbols. So I've given a list of literary works. So like books, periodicals, journals, novels, any manuscripts, letters, emails, all this can be protected under the literary work. So the term literary work in copyright law refers to written or printed matter. So literary work includes, but it is not limited. It is not only limited to these textbooks, but it is also applicable for computer software programs also. So computer software programs is the most common method used to protect software in India. So only under copyright we use in India we protect the computer software. So historically, computer programs were not protected by copyright. Because until 1974, computer programs were not viewed as fixed or tangible objects. Because as a requisite, I told you that the copyright should be fixed in a medium, some tangible object. Because before it was not considered as a tangible object, copyright was not incorporated under the Copyright Act. But however, in 1983, traditional copyright law was extended to include machine-readable software, and the Copyright Act awarded computer programs the same copyright status as literary work. So both the object code and source code can be protected as literary work under the Act. So there is no specific, so again, here I have given you the tables and compilations. So there is no specific meaning given to the terms table, compilation, and databases. But these are also copyrightable subject matter and are protected as literary work. So to obtain copyright protection for a table, compilation, and computer databases, the work must exhibit some creativity or originality in the selection or arrangement of the contents of the work. So the prerequisite to apply for this literary work for computer databases is that you should have some creativity, originality, and arrangement of the content of the work. So if the labor and skill required to make the selection to compile the tables for which form it means is negligible. If it is negligible, then no copyright can subsist in it. Now coming to copyright registration for website. So even see, when you take a website usually consists of different copyrightable subject matters. So what is website? A website may be understood as a web page or a set of interconnected web pages hosted or stored on a server and is made available online to members of public. So users can access the information on website through various means such as scrolling web pages or using internal hypertext links or a search feature. So generally website consists of different components which are copyrightable subject matter that falls within any one of the classes of the Copyright Act 1957. So if you take the components like digital files such as text, tables, computer programs, compilation, including computer databases, all that will come under literary work. If you have any photographs or paintings, diagrams, map, chart, or plan in your website, that will have to be protected under artistic work. So, but if you have any music or graphical notation of any musical work, then that should be protected under musical works. Or if you have any sound recordings of, or if you have a small film there, it has to be protected under the cinematograph. So website as a whole, you cannot protect it under the copyright. So if you want protection, applicant is required to submit a separate application for each of the component appearing on the website. So if you have any literary content, that has to be protected under literary. So if you have any musical content, that has to be protected under musical work. So a website as a whole is not subject to copyright protection. So now coming to musical and dramatic works. So what is musical work? So a musical work is the composition itself and does not include the lyrics or any sounds. So here I mentioned that it is the composition itself and it does not include lyrics or sounds. So the lyrics of any musical work is protected under literary work because the poetry or lyrics, that writing will be protected under the literary work. And if any sound, a sound medium is there, then it will be protected under the head sound recording. So here here only the musical notations are protected under the musical work. So coming to the dramatic work. So dramatic work includes a piece of recitation or choreographic work or entertainment and dumb show or the scenic arrangement or acting. So the form which is fixed in writing otherwise but does not include a cinematograph. So what is dramatic is it has to be it can be converted into a writing form. So then it will fall under the category dramatic work. So a dramatic work is something that is capable of being written or printed or reduced to some permanent form. So whatever you have written, if that can be converted to a cinematograph film, then it will be considered as a dramatic work. So it does not include a cinematograph film and it indicates the mode by which it should be expressed. So the next type is artistic work. So this definition, the definition of artistic work as laid down in Copyright Act is fairly comprehensive and descriptive. So copyright in any original artistic work comprising of like paintings, sculptures, graphics, cartoon, photography, drawing, plans, map, diagrams, chart, models of buildings, sculptures, all this will come under the head artistic work. So I've given the work of architecture. So work of architecture means any building or structure having an artistic character or design or any model for such building or structure that can be protected under artistic work. Now coming to sound recording. So as I told earlier, the medium of that sound means a recording of sound from which such sounds may be produced regardless of the medium on which such recording is made or the method by which the sounds are produced can be protected under the sound recording head. So by definition, any recorded audio will be considered as a sound recording. For example, a song, a recorded speech, or an audio book. So all this will be protected under sound recordings. Next is cinematograph films. So this is any visual recording like videos, short films, movies, animated movies, documentaries will be covered under cinematograph films. So any visual recording includes moving images also. And therefore, any recording of moving images like photographs. So any photograph, if it is converted into moving images, then it will fall under the head cinematograph film. Now, what does the copyright not protect? So what all will not fall under this copyright category? So copyright does not protect names, so titles, songs, or short phrases. So in some case, these are, because since all these are protected under trademarks, so names of the product or titles cannot be protected under the head copyright. So however, copyright protection may be available for logo artwork that contains sufficient authorship, or in some circumstances, an artistic logo will be protected under copyright. So now, who owns the copyright? So for each type of copyright, who will own the copyright of the work? So in case of the author of the work is usually the first owner of such work. So the concept of first owner under the copyright law is quite important. So in case of literary, dramatic, artistic work, it is the author, artist, or dramatist who will own the copyright. So I have given you who will, so literary work, the author will be owning. So the cinematograph film, the producer. So for musical work, it is the composer. For artistic work, it is the artist. And for the dramatic work, it is the dramatist. So for sound recording, it is the producer. For photograph, which comes under the artistic work, it is the photographer. So like this, the first owner of the copyright, that list I have given it here. But there are some exceptions. So as to who will own the copyright. So the concept of work for hire. So though not expressly covered under the Copyright Act, it is implied that the copyright in any work created on commissioned basis shall vest with the person creating such work. So whoever, if you hire someone to do a wooden work, so it is the person who has created the work will have the copyright protection. So in order to vest the copyright with the person commissioning it, in case if you want the commissioner to become the owner of the copyright, that can be done only by assignment in writing, that shall be necessary. Next, in case of work made during the course of employment, so under a contract of service or apprenticeship, the employer, generally in course of employment, the employer in the absence of any contract to the contrary will be the first owner of the copyright. And in case of government work also, in the absence of any contract to the contrary, the copyright in the work will vest with the government. So any work which you have undertaken to do on behalf of the government, the copyright will owned by the government only. So in a, see here in a musical sound recording, generally the lyricist who wrote the lyrics will own the work, the composer who set the music, the singer who sang. So if you want everything to be owned by the producer of the sound recording, then each of the work performed by the individual has to be assigned to the producer of the sound recording. So how to represent copyrights? I think you will be aware of all this. So any book, if you see, you'll be finding all these representation of that copyright. So all rights reserved, copyright 2022, or this C symbol. So this copyright symbol. So anything of these can be used to represent that it is a copyrighted work of yours. Now coming to rights in copyright. So there are two kinds of right. So one is moral right, and the other is economic rights. So economic rights allow right owners to derive financial reward for the use of your work by others. So if your work is used by others, you can gain economic, you have this economic right. So I have given certain bundle of rights which come under this economic right. So one is the right of reproduction, communication to the public, adaptation and translation of the work. So what is right of reproduction? The reproduction right grants the copyright owner the ability to control the making of a copy of the work. So if you have a book in your name, so you will have the control to make copies of it. So it is arguably the most important of the right, as it is implicated in most copyright infringement disputes. Now, communication to public means making any work available for being seen or heard or otherwise enjoyed by the public directly or by any means of display. So this right enforces the copyright owner's basic and exclusive right to control the use of their work. Now, next is this translation and adaptation. So exclusive right, it is again an exclusive right of authors to either make translation or adaptation to make any work, to reproduce the work, issue copies, perform and make cinematograph films. Also based on your work, you can authorize someone else to convert it into a cinematograph films or sound recording. So the next right will be the moral right. So moral right allows authors and creators to make certain actions to preserve and protect their link with their work. So for each head, I have given what all right is given. So what all benefits you have for each and every right. So under copyright protection, benefits include, as I mentioned earlier, it is the right to reproduction, modification, all that. So in case of literary, dramatic or musical work, you have exclusive right to reproduce, including storage in any medium by electronic means, or issue copies, public performance, or make a film or sound recording in respect of that work, to translate or to adapt the work, and the right of communication to the public. So all these rights you have with respect to literary, dramatic or musical work. So in case of artistic work, to reproduce the work in any material form, copyright in an artistic work also includes the exclusive right to communicate the work in public, issue copies, include it in the cinematograph. So whatever artistic work you have done, that can be included in a cinematograph film, or translate or adapt the work in any manner. Now, in case of sound recording, you have right to make other sound recording, embodying it in any medium, including storing of it in any medium, to sell or give on commercial rental or for sale such rental, or to communicate the sound recording to the public. So all these rights are attached to the sound recording. So in case of cinematograph films, to make copies of the movie on any medium, electronic or otherwise, including copies in the form of photographs that form a part of the movie, or sell or give on hire, or to offer for sale or hire of any copy of the movie, like distribution right, all these are attached to the cinematograph film. Now, what is moral right? So, under moral right, you have the right to publication, right of paternity, right of integrity. So, publication, you all know. So, I'll just explain what is right of paternity and right of integrity. So, the concept of moral rights relies on the connection between an author on the work created. So, moral rights protect the reputation of the author rather than the economic value of a work. So it is a goodwill or reputation which is attached to the author. So the moral right of the author always rests with the creator, even when it is transferred. So even when your copyright work is transferred to a third party, this moral right will be attached only with the author. So what is right of paternity? The right of paternity is the right of the author to claim authorship over his book and have it attributed to him. So even when the ownership was transferred to a third party, the authorship remains with the author who has created the work. So that is right of paternity. Now, right to integrity permits the author to restrain or claim damages in the event of any distortion or modification or any other untoward act done to his work. So even if his work is being assigned or sold to a third party, if any sort of distortion or a modification happens to his work, but it can be for fair use, it can be done. But if any other distortion or modification is done, then he has a right to claim damages. So this right is called right of integrity. Now, even after the author's demise, his legal representative has the right of paternity and integrity. So, moral rights exist in perpetuity and are vested in the authors and their legal representatives, being non-transferable and enforceable by the authors and legal representatives, even when the copyright in the work has been assigned. So even when the work is assigned, the moral right rests with the author and his legal representatives. So now, is copyright registration compulsory? So see, activities like writing a book, making a movie, creating a song, or writing a book need a lot of energy and resources. So a writer spends years on one book, and making a movie may spend crores. You spend crores of rupees to come out with a single hit film. So if someone decides to copy a novel or make a movie, a copy of the original, it could cut into the sales of the unique product and lead to losses for the original creator. So the individual then seeks the recourse of law to protect their original work from getting copied by getting a copyright registration. So to avoid all this, it is better you get a registration. So under Indian law, registration is not a prerequisite for acquiring a copyright in a work. So a copyright in a work is created when the work is created. So when the work is created, you automatically get your copyright for it. But registration is actually not required, but it gives you additional protection. So the copyright provides for copyright registration procedure. But unlike US laws, the Indian law registration does not confer any special right or privileges with respect to the registered copyright work. So the the registration certificate will be a prima facie evidence of particulars entered therein. So if in case of any infringement action, your registration certificate will act as a prima facie evidence. So the registration certificate are admissible in evidences in all courts without further proof of original. This registration only raises a presumption that the person in the register is the actual author, owner, or right holder. So the presumption is not conclusive. Supposing when there is a contrary evidence, forthcoming. It is not necessary to render forth to prove the. He has to actually prove that it is the original work of his. So, in case of infringement suit and criminal proceedings, when time is of essence to obtain urgent orders, registration is of tremendous help. So, copyright notice is not necessary under the Indian law to claim protection. Now, coming to duration of copyright work. So, generally, the duration of copyright work varies according to the type of work, the date, and the date of creation of the work. So, if we take literary, dramatic, and musical work, the copyright expires after 60 years from the end of the calendar year in which the author dies. So, for literary, dramatic, and musical work, after the death of the author, 60 years protection. So, when there is a joint author or co-author, when there are two authors for a literary work, then it expires 60 years from the end of the calendar year in which the last author dies, meaning the second author dies. So, when the author's identity is unknown, there are cases we do not know the identity of the author. In that case, it will be 60 years from the date of publication of the work. And then, so until then, the ownership rests with the copyright holder. Now, coming to the cinematograph film, the copyright shall subsist until 60 years from the beginning of the calendar year following the year in which the film is published. And for sound recording also 60 years from the beginning of the calendar year following the year in which the sound recording is published. So with this, I have completed the types of copyright, the duration, the rights involved in copyright. So now I'll ask my colleague, Ms. Shelley, to speak about the infringement of copyright, the registration process in India and international.
Thank you, Filma. Hello, everybody. So I would be discussing on the copyright protection, including the registration in India, international, and also I would be talking about the assignment, license, and infringement of your copyrights. Give me a minute, I will share the screen. I hope everybody can see the presentation. Can you all see the presentation?
Yes.
All right. Okay, so in the previous session, we got an insight into what copyrights are and the categories of work and the rights encompassed in it. So now that we have seen what the copyright, let us see how we can protect it. So I would be reiterating what Ms. Filma has already mentioned about registration not being necessary, and also about what are protected, meaning the expression of an idea or thought when it is put on a tangible medium, copyright comes into existence. So as soon as the work is created and no formality is required to be completed for acquiring copyright. So it means that it is an inherent right and it is automatic. That is, the minute an idea is put into an expression on a medium, a tangible medium, be it on a paper, be it on a CD, then the copyright is automatically created. So therefore, it becomes important to protect it, because how will you otherwise prove that you are the owner of the work that you have created? So when we talk about protection of copyright for the work that is created, it means protecting it from unauthorized use by any third party. So we keep saying that protection. When you say protection, does it mean that you're locking it away and not letting anybody else see it? So there is no purpose of you creating a copyright and not utilizing the rights that the copyright is provided to you, which is the monetary benefit, and also for the society to benefit from the creation of yours. So, as discussed earlier, the author of the work or the owner of the copyright alone has the right to exploit his or her work commercially. So, no third party without permission from the owner can use the copyright that you have created. So, protection of copyright means protecting it from unauthorized use, that is, without permission by any third party. So the author of the work can either authorize or prohibit any third party from reproduction of the work in any material form, such as print, sound, or video. And not only reproduction, it also, the author also can authorize or prohibit anybody from storing it on any medium by electronic means. And the author can either authorize or prohibit anybody from making copies and issuing copies of the work to the public, which are not already in circulation. Performing of the work in any public area or communicating it to the public without the permission of the owner, or even playing music in public or performance of a play in public without the permission of the owner amounts to copyright infringement. So any person cannot do it without the permission of the copyright owner. It also would be the broadcasting it in various forms, or translate the copyrighted work in other languages, or to sell or give on commercial rental, or create copies for sale or for hire, also cannot be done without the permission of the author. So the author can either authorize a particular person or authorize couple of persons to do certain activities as mentioned, or he can prohibit others from doing either of these activities or all these activities altogether. So all these rights are given to the copyright owner to exploit the creation of his work, that is the copyright that he has created, for monetary benefits. So one way of protecting your copyright is by getting registration. When we seek registration of copyright, it is mainly to establish ownership to the work created and to either authorize or prohibit the earlier mentioned activities. So by doing so, you get to enjoy monopoly and benefit monetarily. So we have already discussed about the registration of copyright, which Ms. Filma has already touched upon. I will be reiterating the same points again. So under the provisions of the Copyright Act, the registration of the work is not compulsory. And if somebody infringes the copyright, having no registration is not a bar to institute a suit against somebody for the damages. Therefore, registration is not a condition required for maintaining a suit for damages. But so now that we have seen that registration is not mandatory, why do we have to have registration? First of all, the certificate of registration actually establishes the ownership as to who owns the copyright. And this certificate acts as the prima facie evidence in a court of law, establishing who owns the copyright and the time of creation of that work, so as to to enable the copyright owner to take any action against anybody who is infringing on his rights. So these are the benefits of having a copyright registered. So what are the works that can be registered? Any work which falls under any of the categories can be registered. That is literary, dramatic, musical and artistic works, computer programs, cinematographic films, sound recordings. So all these things can be registered. What are the requisites for registration? The first and foremost is that the work must be original. When we say work must be original, it means that the idea need not be original, but the expression of the idea must be original. So what it means by that is that the work should not be copied from any other work, and the work must be on any tangible medium. Just by having the expression in your mind will not amount to having created a copyright. It has to be transferred on a paper or a CD or somewhere. It has the expression of that idea should have been there on any tangible medium. Only then you can seek registration for copyright. So while we are going ahead and filing an application for registration of copyright, certain things are to be taken into consideration and disclosed in the application. So the first and foremost is the details of the applicant. So we have also seen that the original authors are the first owners of copyright, and the copyright owners can also acquire the rights from the original authors and become the owner. So now if it gets too confusing for you, just imagine or relate it to a physical property. The property can be built and sold to you, the fresh property, say new property. You buy that property and you become the owner. Similarly, if that property is being sold to somebody else after you got it, then the other person so you are the first owner and the other person becomes the subsequent owner. Similarly, in copyright also, the law says that whoever has created that work is the first owner of the copyright, that is the original author. So anyone who wants to get the rights transfer or wants to own that particular copyright can get that right assigned in his favor and become the copyright owner. So normally the question would arise as to in a place of in employment, whether the employee has the right over copyright that he has created, or the employer holds the right in a copyright. So if there is any, unless there is any agreement to the contrary, the original author, that is the employees who are asked to create that work, even for work for hire or for under the course of employment, if they have created that work, then they are considered to be the original authors. So now in that case, now the employees can move to other company, but he will still be considered the original author. In that case, if the company wants to file a copyright application in their name, so what can they do? What they can do is get all the rights of of the original author transferred to the company, that is the employer, and then the company can file an application. So this is very, very crucial to disclose in the application as to whether the application is getting filed in the name of the author or the copyright owner. If he is the copyright owner, then he has to intimate it to the original author that he is filing a copyright application with the copyright registry, and that the other person, that the owner, the original author does not have any objection with the copyright being registered. So all these documents have to be collated and filed along with the application. So one or two or more person can also co-own a copyright. So they are called the joint authors or joint owners. So Copyright Act facilitates or enables the joint authors to also file application in their name. A copyright application can also be filed for published work and also unpublished work. So like I said, we have to intimate to the original authors and get the no objection from them, and then submit the documents along with the copy of the work. So once we file an application, so the separate application has to be filed for each work. So if you are creating a literary work for say for example a poem in a particular title, and then you are creating another poem in another title, these two cannot be considered as one application. Separate applications have to be filed for both these work, and they will also be looked at as separate work. So they have to be filed in Form 14 in triplicate with statement of particulars, and if they are the original authors, then no objections are not required. But if they are not, if they are the copyright owners to that work, then the no objection certificates have to be obtained. And once we file the application, paying the government fee, the prescribed fee, the Copyright Registry examines the application. So it is not automatic that you file the application and you get the registration certificate. It goes through the process of examination at the Copyright Registry, and if there are any discrepancy or any compliance that needs to be done, the registry will intimate the applicant and ask them to reply for the discrepancy or rectify that, and or comply with the call for compliance letters. And if needed, they may schedule a hearing. And if the registry is satisfied with all the necessary reply or requisite compliance done, then they will proceed to provide you with the registration certificate. So this is the procedure for getting a copyright registered in India. So as we have already seen, the effect of registration in India is that the certificate acts as the prima facie evidence, because it records the time of the creation of the copyright and also establishes the proof of ownership. And the other advantage of getting a registration in India is that it is valid across all member countries of Berne Convention. Now let us see what Berne Convention is all about. So I have mentioned that the registration in India is valid across all the member states that are party to Berne Convention. So as of now, 179 member countries are there with the convention. So since India being a member, the registration in India extends to all the 179 member countries. So now let us see the international protection of copyright. As we have said that in India, it is not mandatory to have a registration certificate. However, having a registration in India helps you protect it in other member countries, that is 179 member countries. As copyrights are territorial rights, meaning the exclusive rights apply only in the country where a copyright is registered. So if one wishes to seek protection of copyright internationally, then the applicability of international treaties come into picture. The major treaty in regard with copyright protection, that is the literary and artistic work, is Berne Convention. What Berne Convention does is it protects an author when their work is published or produced outside their country of origin. So it protects their rights to authorize any translations or reproductions or adaptations of their work or performances, broadcast, etc. So by doing so, it enables the copyright owner to control how their works can be used and by whom it can be used and on what terms it can be used internationally. So before this Berne Convention, there was very little protection for authors outside their home country. But the foundation of Berne Convention, based on the three principles, enables the authors to utilize their use this protection across the globe, or at least in the 179 member countries. So the three basic principles of Berne Convention is that the works originating in one of the contracting country must be given the same protection in each of the other contracting countries. So protection is not conditional or based upon compliances with any formality, and instead it is automatic. So there is no need for any compliances with any formality that is required, meaning that no separate applications need to be filed. So in each of the country that you want registration or protection, say like other IPs, unlike other IPs like patents or trademarks, where international protection means filing applications in that particular region or country or under any international treaty. Registration of copyright in India do not require separate registrations in the member countries. So these are the advantages of registering a copyright and extend protection internationally. So moving on, let us see the assignment of copyright. I did mention before, when the original author owns the right and when the company would like to acquire that rights and get in their name, we will have to get into an assignment agreement, meaning that the original author has to assign his entire interest in the title, that is in the title in the copyright, to the company. Just like a physical property, how when it gets sold, all the rights vested with that particular or the seller gets transferred to the buyer, correct? So similarly, like any other physical property, even copyrights can be bought or sold. So transfer of right in the copyright can either be by way of an assignment or by license. So when we say assignment, it means that there is a complete transfer of rights from one party to the other. So assignment can be generally considered as a sale. So in assignment, the entire right in the copyright gets transferred. Whereas in license, only the interest in the copyright is transferred. So now again compare it with a physical property. So when we rent it out, the ownership remains with the owner of the property. Only you are giving the place for rent for a particular, for the rental money to another tenant. So he can only stay there for that particular purpose that you have rented it out and for a particular period of time. Similarly, in copyrights also, when you are transferring your rights, when the entire rights is being transferred, then it would amount to assignment. But in copyright, in license, what happens is only the interest is transferred, but the ownership remains with the owner of the copyright. So why do we have to look at assignment or license? Copyright is also, it's an intangible property, right? So when we say intangible property, it has some monetary, it's an asset that cannot be seen. So this asset can be transferred or licensed so as to get monetary benefit out of the work that you have created. That is why we are looking at the ways of getting monetary benefit by giving the certain rights or selling entire rights. Now, when we say assignment, like I already said, so the owner of the copyright has the right to assign the copyright to another person. It can be assigned wholly or partly or for the whole period of copyright or for a particular period. So the assignment can be for a work that exists or that exists already or for a future work. However, for future work, only after that work coming into existence can such assignment be effective. So until then, the assignment, even though that can be done for a future work, will not come into effect, but will come into effect only after that future work comes into existence. So the mode of assignment, how can the rights be assigned to other person? Assignment of copyright should be in writing and signed by the author or the owner of the copyright or his authorized agent. Otherwise, that particular assignment will be invalid. Any oral assignment is again invalid and it is not permitted under law. So any assignment that is happening should be in writing and signed. So copyright is different from material object. So mere acceptance of a remuneration or delivery of a manuscript does not constitute an assignment of copyright. So just by passing a book, I am not giving any right or assigning the entire right that I have on the work that I have created, which is the literary work. But I'll have to mention what is being transferred, including the rights, territory, restrictions, royalty, duration. All these things have to be specifically mentioned in the agreement itself. So in case this assignee does not exercise his rights within a year, then the assignment would be lapsed. It is also to be noted that moral rights cannot be assigned or licensed. It is always vested with the original creator of that particular work. Now moving on, let us see what is license. So in a license, only the interest in the copyright is transferred, which we have already discussed. So the right to use a copyright is given to another party with some restrictions on such usage. A license can be given on a work that is already in existence, or can be on a copyright in some future work which is yet to come into existence. So in case of future work, just like assignment, the license can take effect only when such work comes into existence. And the license can be given for broadcasting or translations, including production, reproduction, printing, public for performances, and other kind of activities. So, like I mentioned, the copyright owner retains the title to the work when he gets into a license agreement. So the advantage of giving the license is that the author can monitor the exploitation of work and reap monetary benefit, all while holding the ownership over that particular copyright. Now, let's move on to infringement. So when there is an unauthorized use of a copyright by a third party, that is without a license or permission of the owner of the copyright, then such acts amounts to infringement of copyright. Section 51 of the Act contains exhaustive list of activities that constitutes infringement. So some of the activities that amounts to infringement are anything for which only the owner has the right. That is, if done without the owner's permission, then such activity would amount to infringement. Similarly, any communication of work to the public for profit, or copying, selling, renting, lending the work to someone else. So first of all, that person not having the right cannot even copy or sell or lend, but he is also doing it for monetary purposes for which he doesn't have right to. Then such activities would amount to infringement. So permitting any place for the performance of works in public where such performance constitutes infringement, or distributing for the purpose of trade, public exhibition of the infringing copies by way of trade. Say, for example, someone takes a print of a book that he doesn't own copyright to, and then sell it in a trade or in an exhibition. Then that not only sells it but also exhibits what he is selling, then that also amounts to infringement. And importation of any infringing copies to India also amounts to infringement. So there is a very exhaustive list of activities. For time constraint, I have only touched upon very few activities that constitute infringement. Now, not all acts would amount to infringement. So anyone who infringes knowingly can also claim defense against infringement. So sometimes what happens is that we are not aware of who owns the right and what kind of right is vested with that particular creation or the copyright. So in that case, and we might use it without knowing. That is called that innocent infringement. That is when a person who is engaged in an infringing activity was not aware and had no reasonable ground for believing that such conduct would be an infringement of copyright, then such act would be considered as innocent infringement, because he is not at all aware that he is committing an infringement, and that particular activity of doing certain work also would amount to infringement that he is not aware of. Then it is innocent infringement. And the second type of infringement or the defense against infringement is the subconscious infringement. That means when a person believes that the work belongs to him and believes that he is the original of that work. But in reality, the work belongs to someone else. So subconsciously, he is believing that he has created it and that it belongs to him, and that whatever he does will not be infringement. So this type of infringement is called subconscious infringement, which can also be taken as a defense against infringement. The other main defense against infringement is the fair use. So what is fair use? Let us see it elaborately. The Act provides for, that is, the Copyright Act provides for exceptions under Section 52, where certain acts are not considered infringement of copyright. That is, Section 52 contains an exhaustive list of defenses to copyright infringement and are referred to as fair dealing. So these fair dealings are similar to the principles of fair use. What are fair dealings? So some of the acts that constitutes fair dealings are like using the material or the material for private or personal use, including research, or using that copyright for criticism or review, or if you want to create a parody out of it, provided there is no intention to compete with the copyright owner and that no improper motive to create that work is established, then it will not amount to infringement. And then reporting of current events, current affairs, reporting of lecture delivered in public. So all these things will not will be a defense against infringement because it will fall under fair use. But there is an exception to this, that the publication of the compilation of address and speeches delivered in public will not be considered as fair dealing. So reproduction of any work for the purpose of judicial proceedings, adaptation of computer program, but only in order to utilize it for the purpose or to make backup against any loss or damage purely as a temporary protection, then it will be considered as fair use. And also, when you say a store, like incidental storage of a work in the technical process of electronic transmission, like a data that you are storing to the and communicating it to the public, does not constitute infringement of copyright. So these again, just like how activities of infringement are listed out, it's an exhaustive list. The fair use under Section 52 also is an exhaustive list. I have only provided very few examples where such activities can be regarded as defense against infringement under fair use principles. Now, that let us now see what are the remedies available when your copyright is infringed. Now that we have seen infringement, how can you as a copyright owner avail remedies? So the Copyright Act provides civil remedies, criminal remedies, and administrative remedies. The civil remedies and criminal remedies are usually the practical remedies that are available for a copyright owner. So under civil remedies, the owner of the copyright is entitled to remedies by way of injunction, damages, and accounts of profits. So he has the right to sue for injunction. That is, only a copyright holder or exclusive licensee can sue for infringement of copyrights for either damages. That is, what does damages mean is that damages are compensatory in nature and make good the loss caused to the original copyright owner or the original author. So the other civil remedy available to the copyright owner is right to sue for accounts of profits. So it is an equitable remedy whereby the infringer hands over the profit that he has made by infringing the copyright content. So he has to transfer or hand over the entire profit he has made to the copyright owner. So under civil remedies, the copyright owner has the right to sue for injunction, that is to temporarily stop, temporary injunction or permanent injunction, stopping the unauthorized use by any third party of his copyright, and also can sue for damages that it has caused to the owner, and also ask for the account of profits that the infringer has used to make profits out of. So these are the rights vested under civil remedies. Apart from civil remedies, the copyright owner can also seek criminal remedies. So under these criminal remedies, they provide for imprisonment, fines, seizure of infringing copies, and delivery of infringing copies to the owner. So any CD in black market, any movie CDs or anything, you can take criminal action against the infringer by putting them under bars, or also seek fine, and also seize whatever has been infringed upon, the copies that he has created and kept it aside. All those can be seized and taken and handed over to the copyright owner. The other type of remedy is the administrative remedies. Say this is more of when you want to file for moving the registrar to ban the import of infringing copies and delivery of confiscated infringing copies to the owner, then you can just seek administrative remedies. Now we have seen infringement and what are the remedies available to the copyright owner when his copyright is infringed upon. Can also look at preventing the infringement. So how can you prevent an infringement? There can never be that infringement free utilization of copyright or monetizing or commercial viability of a copyright without any infringement. Infringement is bound to happen, but you can prevent it to some extent by properly noticing or giving notice of copyright. That is, earlier we had seen the copyright symbol or the copyright belonging to so and so, copyright published under so and so. So wherever possible, give notice that the particular work belongs to you or copyright of so and so. And then having registration of copyright, though it is not mandatory, it helps you establish ownership. The third is documenting the instances of use. So wherever you are using and you're not very sure who owns the copyright, you can always document for what purposes you have taken and how you have taken and how you are using it, so that you can also create a defense against infringement if somebody comes and sues you for infringement. So that's why you have to document the instances of use. The other one is the monitoring the activities of infringers, both offline and online. So now with everything going online, you get to see so many infringers just taking a photograph from your account and then removing the watermark and then posting it on their website or on their page. So these infringers are unstoppable. So what you can do is you have to monitor the activities of these infringers, that they are called the habitual infringers. You'll know who are the habitual infringers or not. So monitor it and then take necessary action as and when possible. The other one is to incorporate confidentiality clauses and control mechanisms when you are transferring any particular right to another person by way of having all these things envisaged in an agreement. So these are some of the ways that you can prevent infringement. Now let us see the enforcement. So the copyright owner can enforce his right by initiating a copyright infringement action by filing a suit or civil proceeding before a district court or above. So apart from filing for a suit or civil proceedings before the district court, the copyright owner can also enforce his right via copyright board. This copyright board is constituted by the central government to discharge certain judicial function. So the board has the power to adjudicate any registration or decide disputes on any assignment or granting of licenses related to published and unpublished works. So if or any translation of or any work withheld from public. They also have the power to rectify the register. So if you're for copyright infringement cases, you can approach the district court. But if it is related to the other areas of getting the discussion with the assignments or getting particular licenses granted, or if there is any error in the records of the copyright registry, then you want that to be rectified, you can always approach the copyright board. So why we say enforcement is important is that having ownership to a copyright is one thing, but when you are utilizing your copyright or giving rights for a certain activity, for publishing or for only broadcasting, so in that case you will be getting royalty, that is the monetary benefit. So if somebody infringes, you will have to enforce the rights that is vested by this copyright, so as to say that you are the owner. Just like how a physical property is properly fenced and protected, and you do not let any trespassers come in, stay here. If anybody does so, you take them to the court, right? Or you take a proper action, legal action. Similarly, you have to enforce your rights so as to establish you are the owner, that you are the only rightful owner of the work that or the copyright you have created. So this IP life cycle encompasses everything, that you create copyright, you protect copyright, you utilize your copyright, and then you enforce the right. So this is a cycle. So copyright and the law continues to evolve with growing world of technology. So it is prudent to protect the copyrights that are created and enforce it effectively to not only benefit from it, but in turn you are also enriching the society. So with this, I would like to conclude. I would be happy to take any questions if you have. Any questions, Filma, and I can take up. I also see few. Can everyone hear me?
Yes, ma'am. Ma'am, they put the questions in the chat box.
Yes, yes, I'm going to address. Filma, will you be doing it? Or?
Yeah, I'll take first few questions. So the first question was, why is there different term of protection for music and sound record? So I think you didn't get what exactly is musical work and sound recording. See, sound recording basically it is a composite right. So it includes the lyricist who wrote the lyrics, the composer who set the music, the singer who sang the song, the musicians who performed the background music. So everything will be together called as the sound recording. So the person who sound recording, who does that recording work, will be the producer. So he will own the work. When all these work, the person who have performed this one, the singing work and the lyricist, they all should assign the work to the producer. So each one will have right over their work for the sound recording. So as I told you, the music, the notations which come under that for that sound recording will be separately protected as musical work. I've got it.
And also, there is another question: why copyright is known as negative right?
See,
so, yeah, please.
See, it is negative right because the copyright owner has right to prevent others from using his work in certain ways. He has right to claim compensation. So just because he has a right to prevent others to use his work, we call it as a negative work. The next, someone has asked give an example how to protect the copyright website, to protect a website under copyright law. See, basically, copyright, this website has so many components which are copyrightable subject matter. See, like you will, in a website, you will have text or some literary work there, some computer programs, some photographs or painting, some diagram, some everything will be there, but altogether cannot be protected as one copyright work. So if you take a website, you have different components which has to be protected under the different type of copyright. So like literary work will that computer databases will come under literary work. All the chart or map or painting or photograph, whatever is there in the website will has to be protected under artistic work. If you have any graphical notation, music, then it will come under musical work. If you have any short films or some video running, that has to be protected under the cinematograph film. So each feature has to be protected under the different type of copyright. You cannot on the whole protect the website under copyright. As one application, you cannot protect. You have to file different applications under each category.
Okay, so another question on, do we get same rights under Copyright Act even when we have registered even when we have not registered our work under copyright, right? Yes, you get the same rights, but as we have mentioned, for unregistered work, there is no bar if somebody infringes on your copyright. But you can, just like a registered owner can seek remedies by filing a suit before court of law. But in order to establish ownership, see, just like a physical property, you are paying and getting the right to the property. You are getting it in your name, but you are also registering it with the appropriate office. Why are you doing that? Because it all establishes that you are the owner and acts as the proof. Similarly, having registration helps you establish that you are the owner, and also eases the process of seeking any injunction against any infringer. So that is why registration, though not mandatory, is advisable to get one, highly recommended. So the other question about published work, and does blog writing comes under published work? Filma, you'd like to take, or I shall?
See, published. What? First, I'll explain what is published work. So it is communicating to the public, which means that when any public can is access to your work, then we call it as published work. So by writing a blog, when you put it to the public, then it will come under published work. So the public is able to see your blog, so it will come under published work. So when it is able to be seen by any third party or public, then we call it as published work. And we put copyright symbol on our without. Yes, you can put copyright symbol, because once you your work is completed, it means that you have copyright to your work. So you can even without registering the copyright, even without registering the work, you can use the symbol.
Why is the different term of protection for music and sound recordings? Kalma, would you like to take it?
See, as I told you, the sound recording is a bundle of rights. It does not only have, because as I mentioned in the website, you have so many copyrightable features in the sound recording. But musical work is just the music, that background music, that notations is only protected under the musical work. So that's the reason why we have a separate type of copyright called as sound recording. And not only, see, don't relate the sound recording only with respect to music. See, even audio, audio book is protected under sound recording. So what the example which I gave you will have relation to music, but even the audio books are protected under sound recording. A lecture is protected under sound recording. It will not come under musical work. That's the difference why we have two types of copyright, that musical separate and sound recording. Can we say lectures, when we give lectures, can that be brought under the musical work category? No. So that will come under sound recording. But in fact, even music has a sound recording. It has a medium through which it has to be recorded. That's the reason why this, but it does not only have a music. It has a lyrics there. It has a composing work there. It has background music. So that will be that the medium through which you record will come under the sound recording category.
So the last question is, have not registered your work under copyrights in India, but whether you would get protection in other country also. Technically speaking, yes. However, if you are to take it to other countries, how will you establish that you are the owner? So it takes a lot of paperwork, and there will be, to enforce your right effectively, registration will help. So that is why, though it is not mandatory, it is highly advisable to get registration. I hope with this we can conclude. There are no more questions.
I would like to Ms. Priya to propose a vote of thanks.
Good afternoon, everyone. It's an honor to propose the vote of thanks for today's session. I would like to thank the Almighty for making today's session a success. I extend my gratitude to our speakers, Ms. Filma Varghese and Shelly Anandavalli, for taking the time to be a part of the FDP on research and IPR, and for sharing her knowledge and insights. I thank all the participants who have taken the time out to attend today's session. A big thank you to our secretary, associate secretary, for the constant guidance and support. My special thanks to our principal, Dr. S. Bhatmavati, and vice principal, Dr. S. Rukmani, for giving us the encouragement we always need. Last but not least, I would like to thank Dr. S.T. Deepa, our internal technical team and internal training team, for all the efforts and coordination for this session. Once again, thank you all. Thank you, ma'am.